Suing is not a good word. An applicant has to file an initial application for Social Security disability benefits, which is reviewed by the local Office of Disability Determinations. That office will gather the medical records and have those records reviewed by a physician on staff. About 75 to 80% of the initial applications are denied, which means that you must go to step 2, which is filing a request for reconsideration. And guess what? The request for reconsideration goes back to the same office that denied you the first time. And as you can expect, the denial rate is just as high. What happens then is you have to file what's called a request for a hearing. And that request for hearing has to be filed within 60 days of the denial of request for reconsideration. Unfortunately, in the United States, there's a significant backlog in getting the case in front of an administrative law judge, who is the person who will ultimately determine whether someone is entitled to benefits. Here in the Tampa Bay area, the delay is anywhere from about 18 to 24 months. And so in that time frame, our law firm continues to gather the appropriate medical evidence. We use what's called residual functional capacity forms that we have physicians fill out. The Social Security Administration never tells anybody about residual functional capacity forms, and those are forms that are designed to help your physician answer the questions that Social Security is looking for. What's the diagnosis? What's the objective basis of the diagnosis? Does it meet a listing? And if it doesn't meet a listing, then the form helps the doctor set forth the restrictions and limitations that you have. Because in this Social Security analysis at step 3, if you don't meet a listing per the guides, then you have to go to steps 4 and 5. And those are what are called medical vocational in nature. At step 4, the Social Security Administration asks, can you go back to the lightest job you held for the last 15 years? And in making that decision, the Social Security Administration, through the administrative law judge, is going to look at the records or the residual functional capacity form and determine whether your restrictions prevent you from doing the lightest job you held in the last 15 years. If you're able to show proof that you can't go back to that lightest job, then the burden of proof shifts from you to the Social Security Administration to show that there isn't a job that exists in the national economy that you can do based on your age, education, and transferable skills. That residual functional capacity form that your doctor fills out will talk about things like exertional impairments and non-exertional impairments. An exertional impairment would be something like you are limited in the amount of your lifting, bending, or stooping. Non-exertional impairments might be that you have side effects of medication, you have pain, you have fatigue, you have difficulty concentrating. We develop the exertional and non-exertional impairments so that the administrative law judge has the right kind of information they need to determine whether or not you're entitled to the Social Security disability benefits. And in our experience, we win about 90% of our cases, if not more, in front of the administrative law judge. But it takes almost 2 years to get in front of the judge. That's right.